So you can see Brian saying good afternoon. So I think you can actually be able to hear me. So I think we were looking at share capital. So I want us to wind up with the share capital. I want us to wind up with the share capital. So I think we can continue from where we left. We were to look at maintenance of share capital. Maintenance of share capital. So you can look at rules on allotment of shares, or basically how are shares actually supposed to be allotted once the company has actually received the application or subscription for shares. So this is what you are actually supposed to look at, because you've already looked at the types of share capital. You've already looked at our prospectus in deeper details, a misleading prospectus, statement in lieu of our prospectus, what actually happens where we have a misleading prospectus, what happens in a scenario where we have a misleading prospectus. So there's a highlight. This is what you're supposed to know since we started this particular topic. Know the types of share capital, types of share capital, types of share capital. Know what is share capital, what is share capital already. You should be knowing what is share capital already. Because you've already looked at this, you should actually be knowing the prospectus. What is a prospectus? In this regard, you should actually be understanding a statement in lieu of a prospectus. You should actually be understanding what is a misleading prospectus. What is a misleading prospectus? What is a misleading prospectus? And in this regard, should actually be knowing what are the remedies with regard to a misleading prospectus. Remedies to an investor as a result of a misleading prospectus. What are the remedies that an investor actually has if there's actually a misleading prospectus? You should actually also be knowing what are the contents of a prospectus. The contents of a prospectus. The contents of a prospectus. You should actually understand the contents of a prospectus. Then be able also to know methods of issuing shares. Methods of issuing shares. I think this is the last thing we actually looked at. So we say there are different ways under which shares can actually be issued, or the company can actually issue its shares. So maybe we can have direct offer. We can have offer for sale. We can have placing. We can have tendering. We can have a rights issue. So you should be knowing this one as we move on with the topic. Assessment in lieu of prospectus. We say this is a presentation of a prospectus that is issued privately by companies, more so by companies that want actually to basically private companies wanting to turn out to be public companies can issue a statement in lieu of a prospectus instead of a normal prospectus. The contents, basically details to do just with the shares that are actually going to be issued. There'll be the name and address of the company on that particular prospectus. There'll be the classes of shares going to be issued by the company. When is the date of opening of the subscription? When are members of public allowed to start subscribing for the shares? Who are the directors of the company? How many qualification shares do they actually hold as directors of the company? Are the shares, what is the nominal value or the price of the shares that are going to be issued? The prospectus will be signed by the directors, so they are the parties who actually approve the prospectus in the company. Then a misleading prospectus, as prospectus containing untrue information about the company. What are the remedies you as an investor you have if there's a misleading prospectus? You have remedies against the company. You have remedies against those involved in preparing the prospectus, like directors, like promoters. So all those you should actually be able to understand or actually be able to summarize when we talk about the topic of share capital, since we actually started. So also remember that we said on our prospectus, it won't just be the prospectus alone with regard to the contents. There are key reports attached to the prospectus, like financial statements, like in the last 5 years, must be attached on the prospectus. We said payment of dividends, reports to do with payment of dividends, how the company has actually been able to pay dividends in the last five years. The last 5 years. How the company has actually been able to pay dividends in the last 5 years. Then if the company intends to invest in a special project, a report by an expert of how the company wants to, or which project the company wants to invest in. Is it actually viable or not? Then we looked at the methods. So I think I left an assignment that you are actually supposed to look at. So I don't know if you guys were actually able to look at the assignments that I left yesterday. So I don't know if you're actually able to look at it. Were you actually able to look at the assignment? So there's an assignment I left with regard to share capital. So I think I've muted everyone. So I think there's no background noise at the moment. So are you able to look at the assignment? So you can just simply say yes or no. You simply say yes or no. So Edward was actually able to look at it. I don't know if the others were actually able. So Helen was actually able to look at the assignment. What about the others? So maybe I can give you time until the next class. That's when we can actually be able to revise it. So you can still go through it. You can still go through it. We'll just look at it in the next class. But I think we can proceed from where we actually left. So after the company has actually issued its shares, then it, of course, they have to allot the shares. So basically you've subscribed now for the shares. So the company has to allot the shares. So what are the rules that are actually supposed to be followed when the company is actually allotting the shares? So when you talk about allotment, it's basically just the distribution of the shares after maybe you have actually applied for the shares as an investor. So the company has to decide on how much shares you're actually going to get as an investor. For example, if you subscribe for the shares of the company. So when you talk about allotment, it's basically the acceptance. Allotment is the acceptance of an offer whereby basically, this one is basically, allotment is basically the acceptance of an offer by an investor to acquire or basically purchase the shares of the company, to purchase the shares of the company. So basically, an investor gives the company the offer of actually purchasing the shares. So once they actually allot them, then basically now the contract is actually complete. So, for example, say under a contract or any contract, there must actually be an offer and an acceptance. So the investor is giving an offer. Then eventually when the company allots, there's actually an acceptance. So basically the allotment now completes the contract of this particular investor actually being able to purchase the shares of the company. So when they allot, basically it means they have actually accepted your purchase of the shares. So the contract is seen to actually have been completed when basically they go ahead and actually allot you shares. Now you become a member of the company. So in such a case, allotment is basically the acceptance of an offer by an investor to acquire the shares of the company. So the rules that must actually be followed when the company is allotting the shares. So number one, which is actually very key. So the shares must actually be allotted by the proper authority. So allotment of shares must be done by the proper authority, must be done by the proper authority. And of course, the proper authority to be able to allot the shares is actually the board of directors. So the board of directors are the ones who are actually mandated to allot or basically accept the distribution of the shares or decide on how the shares are actually going to be distributed. Then the allotment should be done within reasonable time. So allotments should be done within reasonable time. So the allotment should be done within reasonable time. Otherwise, this particular applicant or basically the investor can decide not to accept once he is actually given the shares. For example, if they wait for a very long period of time, you applied for the shares or basically subscribed for the shares, maybe they have waited for like over a year. So you no longer have an interest in the company. In such a case, you could actually basically refuse to take up the share. So the allotment should actually be done by the company within a very reasonable time. Then another key thing, this particular allotment should actually be communicated to the investor. So allotment should be communicated. So the allotment should be communicated to the investor, communicated to, you can say, the allotee of the shares. So once the board has actually approved, they have decided they're going to give you this number of shares, they should actually be able to communicate to you as an investor, these are the number of shares you're actually supposed to get from the company. So under the law, it is actually concluded that communication is actually sufficient once the company is maybe able to make the communication either through via post or through any means. So once they post that particular letter of allotment of the shares, that is actually concluded as being an acceptance. So that is actually concluded as actually being an acceptance of the shares. So communication, so they must be communicated to the applicant so that it is legally complete. So it will actually only be complete once they have communicated, they have allotted you shares. So that's when the contract is now actually complete. So if basically they allot you the shares and they don't communicate, then now you as an investor, you won't actually be able to know whether they have actually your application has actually been approved. So that particular communication is actually very key. So they communicate to you the number of shares they have allotted you. That's when now it is actually seen as that this particular agreement now between the company and you as an investor with regard to the shares is now actually complete and legally binding. So it will only be legally binding if they communicate to you the number of shares they have actually been able to allot you. So communication to the allotee or the investor on the number of shares that he has actually been given. So it is completed immediately. The letter of allotment is actually posted. So once they immediately post the letter of allotment to you as an investor, that is actually conclusive evidence that they have actually been able to complete the agreement between you as an investor and the company. Then revocation of application may be done anytime before the allotment is done, and communicated via post. So revocation application may be done. So revocation can be done anytime. So number 4, revocation can be done anytime during the allotment and should actually be communicated to the investor, either through any means or via post. So the allotment, if they allot you shares, they must communicate. If they have actually revoked your application, then they must actually also communicate via post. So the key thing here is that so long as the company has actually been able to prove that it has actually communicated, then now the allotment is seen to actually be complete, or now the contract between the company and the investor with regard to the shares will be seen as actually being binding. So communication, once the letter is actually posted, even if the investor has not actually received that particular communication, maybe if it is actually maybe through post, so maybe they sent a letter, but this particular letter has not actually been received by the investor. So the key thing, if they can provide evidence they actually allotted the shares, by sending a letter via post, then that aspect of sending the letter is seen that they have actually accepted, and now there's a contract between the investor and the company with regard to the purchase of the shares. So the investor receiving the letter is not actually necessary. The key thing is that the letter has actually already been sent out. And basically, this is actually explained. There's a case law. If you check in the notes, it is known as National Savings Bank Association case, where we had H applied. They are saying H applied for the shares in a company. The shares were allotted to him, but the letter of allotment was sent to the company's agent for delivery. So instead of actually sending the letter via post, they send the letter to an agent to deliver the letter. So by hand to the investor. So after allotment, but before the letter of allotment was delivered to him, H withdrew his application. It was held that H was not a shareholder in the company because he withdrew his offer before acceptance was made. Hence, there was no binding contract between him and the company. So this particular letter of allotment was given to an agent or someone who delivers letters. It was not actually sent via post. It was not sent via post, because I'm telling you that if the letter of acceptance is basically sent out via post, it doesn't matter whether this particular investor has received that particular letter or not. It will be conclusive evidence that the company has actually already allotted the shares. Therefore, there is a binding agreement between the investor and the company. But if the company goes ahead and actually sent out the letter through an agent, then it means that that particular investor can actually revoke the application of the shares anytime, and it should be concluded that allotment or that particular allotment won't actually be valid, because this one is still with the letter. The investor has not already received the letter. Therefore, he revokes his application of the shares. In such a case, allotment will be seen as having not actually been complete, because the investor has not received their letter of allotment, and therefore there is no agreement between the investor and the company. But if the letter is sent via post, that sending out of the letter via post is conclusive evidence, because the letter is actually sent via post. So it is actually presumed that the company has actually already accepted or actually allotted the shares. So this particular case law, this particular agent had not basically delivered the letter, and the investor ended up revoking his application. Therefore, the allotment was seen as not actually being valid. So the only place where, or the only circumstance whereby it could have actually been seen as being valid could have actually only been if the company had sent out the allotment via post. So sending out a letter of allotment via post is conclusive evidence that the company has actually done the allotment and actually accepted the allotment of the shares. Allotment of the shares. So those are the rules that actually govern allotment or valid allotment of shares. So they could ask you, what are the rules governing valid allotment of shares in a company? So if they ask such, remember that it must be made by a proper authority. Then the allotment should actually be communicated to the investor. So maybe through post or through any other means. So allotment should be done within reasonable time. Then the applicant has the liberty to basically revoke this particular application of the shares anytime, so long as he has not actually received any communication with regard to the allotment of the shares, with regard to the allotment of the shares. So you can now look at the statutory provisions that actually govern the prospectus, issue of a prospectus and allotment of shares. Statutory provisions. So this topic of share capital is a topic you need to be very careful with, so because it confuses students a lot, or students tend to forget about it very much because of a few aspects here and there. You are likely maybe to forget a few things here and there. So statutory provisions. So governing allotment of shares, allotment of shares. So basically, when you talk about statutory provisions, we are talking about the requirements of the Companies Act when the company is actually allotting the shares. So what are the requirements or major requirements they must actually conform with when actually allotting the shares, So one of the key things is that the company, or basically any public offer that is actually made by the company cannot actually allot the shares before notifying the registrar. So they have to notify the registrar 3 days before the allotment of the company shares. So they have to, the company should notify the registrar of companies, of the public offer, or maybe the public issue of shares, 3 days before the allotment. So before they allot the shares, then of course they have to notify the registrar that they have actually made a public offer. Members of the public have subscribed for the shares, and they actually intend to allot the shares. So 3 days before the allotment of the shares, or basically distribution of the shares by the board of directors, they have to notify this particular key party, the registrar of companies, of the allotment of the shares. Then where the offer is made to the public, a copy of the prospectus must be duly filed with the registrar. So they must file a copy of the prospectus, with the registrar of companies, with the registrar of companies. So that is actually very key. So they must at least notify the registrar before the allotment. So they must notify the registrar or file a copy of the prospectus with the registrar of companies. Then they must have received at least 5% of the nominal value of the shares before they can allot the shares. So the company should have received at least 5% of the nominal value in form of application fee, 5% of the nominal value of the shares in form of application fee, before they can actually allot the shares, before they can actually allot the shares. Then of course the last key one, the company should have received the minimum subscription stated in the prospectus before they can actually allot the shares. So minimum subscription of the shares, should have actually been received. Minimum subscription of the shares should have been received before the company should have been received before the company. Minimum subscription stated in the prospectus. Stated in the prospectus. So for example, if the company has issued 1 million shares and they intend to raise a minimum subscription of, let's say, for example, 400,000, then it basically means that if this particular minimum subscription or those who have actually been able to apply for the shares have not met this particular minimum subscription, the company won't actually be able to go ahead and actually issue or actually allot the shares. So the minimum subscription of the shares stated in the prospectus must have been received before the company can allot the shares. So they'll only allot the shares if they have met the minimum subscription that is actually stated out in the prospectus of the company that was actually issued to invite the members of the public to buy its shares. Then another key thing that the company will actually do, once they have actually allotted the shares, now they have already distributed, they have followed all the procedures or the rules, they'll actually basically do what is known as a return of allotment to the registrar of companies. So they'll basically give a report to the registrar. So they'll give a report to the registrar how they have actually been able to allot the shares. So saying, of course, before they allot, they have to notify the registrar 3 days to the allotment. But after now they have actually also allotted the shares, then of course they have to do what is known as a return of allotment to the registrar of companies. Basically, the return of allotment to the registrar of companies, it will basically entail how they have actually been able to allot the shares, who has received the shares, what was the nominal value of the shares, which consideration was actually paid for the shares, was it cash, were they actually giving free shares, what basically was actually the consideration of actually being able to issue or actually allot this particular shares. So we have what is known as a return of allotment. A return of allotment after following all the procedures or requirements according to the Act. Then, of course, after they have allotted the shares or distributed the shares to the shareholders, they have to do what is known as a return of allotment to the registrar of companies. So it's just a return, or basically you can say it is a record of how the shares have actually been allotted. It's a report that is given to the registrar of companies on how the shares have actually been allotted. So it is known as a return of allotment to the registrar of companies, a return of allotment to the registrar of companies. So what you need to know about the return of allotment is basically just to know what are the contents. But the contents I've told you can derive from just the most obvious things, which are actually basically what was actually entailing the allotment of the shares. So for example, in the return of allotment, there'll be the number of shares and the nominal value of shares that have actually been issued by the company. Then the names and address of those particular allottees who has actually now become a shareholder of the company, who has become now a shareholder of the company. Then there'll be the amount of amount paid for the shares. What was the consideration? What were these shares being allotted for? So this company was actually allotting the shares by basically getting a certain consideration. Were they actually bought by cash? Were they actually maybe given to someone who had actually basically provided a service to the company? So what was the consideration on basically these shares allotted to the members? So it will basically contain the number and nominal value of the shares given or basically issued out or allotted, a description of the name and address of the allottees, then the amount of, if any, paid or payable on each share, what was actually being paid for the shares. Then if the shares have actually been issued for any other consideration, which is not actually cash, then they, of course, they have to explain what was the consideration that they were actually issuing the shares for. Because we are going to see that for maintenance of share capital to be consistent, then of course the company should make sure at all times it issues its shares for cash basis. Because if they fail to issue the shares on cash basis, it means that there'll be a deficit on the share capital. So they likely basically receive amounts which are not actually quite in equal terms with the number of shares that have actually been issued. So if there's any other consideration that the shares are actually being issued for, they have to give an explanation in that particular return of allotment to the registrar of companies. So if they have issued shares for any other consideration, which is not cash, they have to explain in the return of allotment to the registrar of companies. So those basically will be the contents of a return of allotment that will be made to the registrar of companies. And it is a requirement for this particular return to be made to the registrar of companies within a period of 60 days, within a period of 60 days of the allotment of shares. So after they have allotted the shares within 2 months or within 60 days, they have to make sure they have basically prepared that particular return of allotment, return of allotment, and it is given to the registrar of companies, registrar of companies. And of course, I've told you, you need to note the key contents of that particular return to the registrar of companies. So having known basically the contents or basically the rules governing allotment, rules governing allotment and the statutory requirements and what is a return of allotment, then you need to know another thing that is actually very key is what is known as maintenance of share capital. How do you maintain this particular share capital? What are the statutory requirements with regard to how the share capital should actually be maintained? So maintenance of share capital. So maintenance of share capital, how does the company actually ensure it maintains its share capital? How does it actually ensure that it actually maintains its share capital? It maintains its share capital. So of course, you've seen the ways of raising or methods of raising the share capital. So how does it actually ensure that it has actually maintained its share capital? So it is important just from the word maintain. It's like basically protecting the share capital. So when they say maintain, basically to protect, how does it actually ensure it protects this particular share capital or this particular form of capital in a company? You could be asking, why is it actually important for the share capital to be maintained? I already told you previously that share capital is actually very important in the company and is actually usually the fund of last resort to the creditors of the company. Therefore, it should actually always be maintained. So it is a requirement under the law for the company to ensure that its share capital is actually being maintained, because this particular share capital is the fund of last resort to the creditors of the company if the company is actually going to undergo liquidation. So the ways through which maybe this particular share capital can actually be maintained, I've already mentioned some of them. It should always ensure that these particular shares that have actually been issued to raise the share capital are being issued for a cash consideration. Cash consideration. So not in a situation whereby maybe shares are actually being given just for free, because if basically some shares are actually being given for free, that particular share capital reported maybe in the books of accounts, it won't be a true reflection of basically what is the last resort for the creditors at the end of the day if the company is liquidated. So one of the ways in which is actually quite direct and actually quite major is always for the company to ensure that it is actually issuing its shares for what is known as a cash consideration. So according to the law or according to the Companies Act, it is a requirement that the company should not actually issue the shares for any other consideration other than actually issuing the shares for what is known as cash basis. So the issue of shares at a discount is actually very prohibited under the Companies Act. And actually, if the company basically issues shares at a discount, it has to find a way on how it will actually fill up the deficit of that particular discount. For example, it said, for example, getting some funds from maybe the share premium account to be able to cover for that particular discount. So one of the ways in which a company can actually be able to maintain its share capital is basically to ensure that it prohibits the issue of shares at a discount. So shares shouldn't actually be issued at a discount, because that means the company will get less amounts in terms of share capital. Because if they issue at a discount, it means that they are receiving less than what they actually expect. So issue of shares at a discount is actually prohibited. That's number one. Then number two, you're saying basically the company should actually issue the shares for cash consideration and not any other consideration. So payment of shares shall actually be in money worth. Then a company should not actually issue the shares for any other consideration without actually giving an evaluation report or any reason. So of course, you are saying some shares can actually be given for free. You can have free shares being given. But of course, free shares can actually be given, or maybe they could give the shares for another consideration, for example, provision of services to the company, then they give someone the shares. But of course, they have to give an evaluation report, or give a report as to the reason as to why they gave this particular shares, and how do they actually expect maybe to cover for those particular free shares that have actually been given. Then another way they can actually do so is to ensure that dividends is not actually paid out of the share capital. Dividends will likely only be paid out of distributable profits. So there's no way a company should actually go ahead and actually start actually paying dividends out of share capital or the capital contributed by the members of the company. In such a case, they're actually depleting the share capital and not actually maintaining the share capital. So dividends, or basically dividends to the members of the company, shouldn't be paid out of share capital. It can only be paid out of distributable profits. For example, if the company has made profits, that's when they can actually be able to go ahead and actually be able to pay dividends out of the profits made. So in such a case, distributable, or basically dividends, shouldn't actually be distributed out of share capital, but basically it should actually only be out of distributable profits. So those are the ways through which a company can actually be able to ensure that it actually maintains the share capital according to the requirements of the Companies Act. And I've told you, maintenance of share capital is mostly very key. It is usually very protected under the Companies Act, because of one key stakeholders who are actually the creditors of the company. So it basically means that they are trying to protect the share capital, because this could be the fund of last resort to the creditors in case the company is actually going to undergo liquidation. So if there is no any other form of means of actually paying the creditors, they basically resort to the share capital of the company. And of course, when you talk about the share capital being the fund of last resort, it means that this particular share capital is actually represented in many ways or in many forms in the company. Maybe these particular persons actually acquired the shares in the company, then it's actually being represented by the assets of the company. So of course, when the company is raising share capital, this particular share capital is not actually maybe only in money form. So they have gotten the share capital, they have gotten the money gotten as a result of sale of the shares, they have invested in assets. So basically, when they mean maintenance of the share capital, these particular assets are actually being protected. So this particular share capital is represented in many forms in the company. It could be in cash in the bank. It could be assets in the company. So that's why they are saying they basically protect the share capital. And this basically means that indirectly, the assets of the company are being protected for the interest of the creditors in case the company is actually going to undergo liquidation. So that is basically what we mean by maintenance of the share capital, maintenance of the share capital. So those are some of the rules that actually govern maintenance of the share capital. So don't forget about them. So the most key ones you should actually remember: it is prohibited for shares to be issued at a discount. That means that the company is not receiving the real share capital, or the real amounts in terms of share capital. Shares should actually only be issued for money worth. If, for example, if the company issues the shares for any other consideration, they must give an evaluation report or reason as to why they have given such shares. Then another one which is actually very key is this one. Another reason that we normally talk about, that a company shouldn't finance the purchase of its own shares. A company shouldn't actually finance the purchase of its own shares. A company shouldn't actually purchase the finance of its own, finance the purchase of its own shares. It shouldn't actually finance the purchase of its own shares. So we say a company shouldn't finance or you can say shouldn't purchase or finance the purchase of its own shares. It's actually also one of the ways through which a company can actually maintain its share capital. So this one is actually also prohibited under the Companies Act. It is actually also prohibited under the Companies Act. And this one is actually explained by a certain rule known as the rule in Trevor versus Whitworth. The rule in Trevor versus Whitworth. The rule in Trevor versus Whitworth. So there's a rule under the common law that actually also prohibits companies from purchasing their own or actually financing the purchase of their own, purchasing the finance of the company's shares. It's actually also prohibited under the statute for a company to purchase or actually finance the purchase of its own shares. So if you look at your notes, you'll see this particular rule in Trevor versus Whitworth. So it talks about an investor. So there was actually an investor who had actually acquired shares in a company. So the company actually bought these particular shares. So they bought back the shares from the investor. But now they had not actually fully paid for the shares. So what actually happened, the company actually started to undergo liquidation. So this particular investor came in to claim the amount that he had not actually been paid by the company. So it was actually ruled that this particular liability to this particular investor was not actually valid because a company cannot actually finance or basically purchase its own shares. So you're talking about a company and a shareholder, or basically you can just say an investor who had acquired shares in the company. So this particular investor bought back the shares from the company, let's say for example, for a certain amount. So the shares were not fully paid. They were not fully paid by the company. So this particular company did not actually fully pay him for the purchase back of the shares. Then of course, this particular company started undergoing what is known as liquidation, or its life was to come to an end. And during liquidation, of course, you know that all creditors of the company are supposed to be paid all their dues from the company. Therefore, this investor was like now a creditor to the company because the shares acquired by the company were not actually fully paid. But now this particular liability by the company was seen as not being valid because we are saying a company cannot purchase or finance the purchase of its own shares. So therefore, the company could not actually pay the outstanding amounts to the investor because it is actually prohibited for a company to finance or actually purchase its own shares. So this one is actually also prohibited under the Companies Act, whereby they say that the company cannot actually be able to finance or actually purchase its own shares. And of course, I'm telling you, this is actually one of the ways through which a company can actually be able to maintain its share capital. A company can actually be able to maintain its share capital because it is actually the fund of last resort to the creditors. Because if it purchases or actually purchases its own shares, then it basically means that it is actually depleting its share capital. And if it actually depletes its share capital, it means that there won't be a fund of last resort to the creditors of the company once it actually starts to undergo liquidation. So this is actually one of the ways also of how a company can actually maintain its own share capital. So this particular rule, you're going to discover that it does not actually prevail always. There are certain situations or circumstances that can actually, of course, force the company to purchase its own shares. Of course, some of them we've already looked at them. And even when I tell you a company cannot finance the purchase of its own shares, you could be wondering, why are you saying so? And for example, under the scenario whereby we are talking about redeeming preference shares, that is a scenario whereby a company is purchasing its own shares. So that is actually an exception to this particular rule in Trevor versus Whitworth. So you can actually see under redeemable preference shares, we say that the company is going to buy back its preference shares. So in such a case, it means that the company is actually being able to reduce its share capital. So that is actually an exception. So that is actually allowed under the statute. So this particular rule under Trevor versus Whitworth, it does not prevail always. It has its own exceptions. One of them I've already told you, redeeming of preference shares. So if the company is redeeming its preference shares, it means that it is buying back its own shares, and therefore that is an exception to this particular rule. So that is the first one that should actually come to your mind very fast, because you've already looked at it. We've said a company is purchasing its own shares. So why is it right now the teacher is saying a company cannot finance or purchase its own shares? So redeeming of preference shares is actually an exception, where the company can now purchase its own shares. So just a minute, we thought that then we can continue. In the meantime, you can be breathing in and out for a minute. So I think we are back. So we were talking about the rule in Trevor versus Whitworth and its exceptions. So that's one of the dominant exceptions under this particular rule, that states that a company cannot purchase or finance the purchase of its own shares, is basically what you are talking about, the redeeming of preference shares. The redeeming of preference shares is actually an exception. So these particular exceptions are usually categorized into two. We can have a scenario whereby the company is actually purchasing directly or it's financing. So the exceptions under which the company can actually purchase So the exceptions they are categorized into two. You know, there's these aspects where I'm telling you there is purchase, then there's finance. Finance, basically, it means that you give someone funds, then he's actually able to buy the shares. Purchase is whereby now the company is buying directly. So one of them is actually like redeeming or preference shares. We can talk about reduction or valid reduction of share capital. We can talk about a valid surrender of shares by a member of a company. We can talk about a court order ordering the company to buy shares of a minority shareholder who no longer wants to be a member of the company. So we have exceptions under purchase of the shares, direct purchase, and those ones under finance. So financing is giving someone else funds, then he actually basically purchases the shares of the company. So we have those exceptions, which are actually also going to look at. So when you talk about exceptions on direct purchase, whereby now the company can directly purchase its shares. So one of them I've already said is redeeming or preference shares, redeeming of preference shares. You can talk about valid surrender of shares by a member of a company, valid surrender of shares by a member of a company. So the company will be forced to purchase the shares. We can talk about valid reduction of share capital. We're going to look at reduction of share capital, valid reduction of share capital, valid reduction of share capital. So basically, just from the word reduction, the company is reducing its share capital. It decides to reduce its share capital. But of course, there are certain procedures that must actually be followed before it can actually reduce its share capital. So if the company has actually been allowed or followed the correct procedures, then it can buy back its shares and reduce its share capital. So if these are valid, that's why they use the term valid. It must actually be valid. They have followed the right procedures before they can actually reduce the share capital of the company. And this one will see that the court has to be involved, and basically the creditors of the company must actually approve the valid reduction of the share capital. So in such a scenario, now the company can buy back its shares because they have actually validly been allowed to be able to purchase their own shares. We can talk about a valid forfeiture of shares, valid forfeiture of shares, valid forfeiture of shares. Then the last one we can talk about where the company is ordered to purchase the shares of an oppressed minority. So order, the company is ordered, the company where the company is ordered to purchase shares of an oppressed minority. So you're actually an oppressed minority member in a company, so you no longer want to be a member in the company, so you go to the court, then the court actually orders the company to buy back your shares. So you no longer want to be a shareholder in that particular company. So the company will be forced to buy back your shares. So these ones are actually exceptions under direct purchase of the company of its own shares. So under this particular circumstance, now the company is allowed to purchase their own shares. But you're saying, of course, you're saying generally, the company is prohibited from buying back its shares. But under these particular circumstances, then the company has no option, but it will actually end up actually buying back its shares. So these are actually exceptions under direct purchase of the shares of the company, whereby it can directly now purchase its own shares by itself. So you have exceptions under financing, whereby now the company can finance another party to purchase its own shares. So how can the company be able to finance another person to be able to purchase its own shares? How can the company be able to finance another person? So exceptions under financing, exceptions of financing of purchase, financing of purchase of its own shares, of its own shares. Exceptions of financing of purchase of its own shares. So a company can actually be able to finance the purchase of its own shares. For example, if the company has an employee scheme whereby basically they give the employees money, then these particular employees actually end up buying the shares of the company. So they have a scheme whereby they give the employees money, they tell them now you can buy the shares of the company. In such a case, if there's that particular scheme in place, then basically it means that the company is actually financing, it gives the employees the money, they finance them, then of course they come and actually buy the shares of the company. Then another one is, for example, if the ordinary business of the company is to lend money. For example, you can actually talk about a scenario whereby we have a bank. So Kenya Commercial Bank gives out loans. It gives someone a loan out there, then he comes and buys back the shares of the bank. So in such a case, that could actually be an exception. So if the ordinary business of the company is to basically lend money, so they could easily lend someone money and he comes to buy the shares of the company. So he ends up actually coming back to buy the shares of the company. Then another one could be whereby they pay the shareholders dividends. Then those particular shareholders use the dividends to come and buy the shares of the company. Or maybe a shareholder basically just says that don't give me dividends, give me extra shares in the company. So you can see in such a scenario, the company has actually been able to finance the purchase of its own shares. So you can actually talk about ordinary business of the company is actually to lend out money. Then of course, they end up actually giving someone a loan who ends up buying back the shares of the company. So they have actually financed him. Or there's an employee scheme. In that particular company, they normally give their employees money. There's already a scheme for its employees. So they basically give the employees maybe at the end of the year money, then they buy the shares of the company. So if there's a legal or actually valid scheme in place, then the company can actually finance the purchase of its own shares through such a means. Giving out of dividends, The company gives you as a shareholder dividends, then of course you use the dividends to buy the shares of the company. So that is actually an exception under financing of a company's of its own on shares. So you can have an employee scheme, or basically you can talk about the company giving out a loan to an employee, then eventually the employee uses the loan to buy the shares of the company. So in such a case, we can have those ones as being exceptions, or whereby the company can now actually purchase its own shares, So I think we can now just look at a few questions here and there. Rather than us just doing a lot of talking here, you can see how these things have actually been tested in the past. So I want us to, and the examiner likes this one, so you can't afford to miss, to forget about the rule in Trevor versus Whitworth. So he could simply test you and actually ask you, state the rule in Trevor versus Whitworth and give 6 exceptions to the rule in Trevor versus Whitworth. And actually something is telling me this one will come this time because they haven't tested it for quite some time. So it will come in the exam. So what you need to note that most of these particular rules in company law, they usually have exceptions. So for example, the rule of Solomon versus Salmon has its own exceptions. Right now we are seeing the rule of Trevor versus Whitworth. It has its own exceptions. There's another rule known as the rule in Royal British Bank versus Tarquant. It has exceptions. So you can't afford to miss these particular exceptions or actually forget about them. So it's quite important you remember them. Not to forget about them. So you can look at this one. It's November 2017, question 3A. November 2017, question 3A. November 2017, question 3A. I don't know if you. So Helen is asking, what does reasonable time under allotment of shares actually mean? So reasonable time basically means that you should do it within, how do I explain it now? You should do it within the required time. For example, you could imagine a situation whereby you basically applied for the shares like a year ago. Do you think, for example, you could have actually applied, let's give this particular scenario. You've actually applied for the shares in 2020. You've looked at the prospectus of this particular company. You see it is actually a very good company. You can actually invest in it. You actually subscribe for the shares in 2020. Then the company fails to allot the shares within the required time or within a reasonable time. or maybe the reason as to why you basically applied for these particular shares, they had actually made an indication they are basically going to invest in oil by raising the share capital. So you actually wait for maybe they cancel that particular deal of actually basically being able to invest in oil, or maybe they wait for a very long period of time. You know, your interest as a shareholder can actually change anytime, or an investor. So if your interests have already actually changed, and basically now that's when the company is actually giving you the letter of allotment of the shares, and your interest has actually already changed, or they wait for a very long period of time such that your interest as an investor has actually already changed, it basically means that they have not actually communicated within a reasonable time. So if they wait for such a long period of time such that the investor can actually be able to change his mind, then of course you can decide not to basically take up the shares. So long as you can give evidence this particular communication was not made within reasonable time. I've already changed my mind or my interest in the company. I don't want the shares. That allotment won't actually be valid, because investors' interests could actually change very, very fast. So if they don't communicate, and that is actually the mandate of the company, to ensure that they basically allot these particular shares within the required time or within the best time, that will actually be very beneficial to the company, such that the interests of the investors are not likely maybe to change very, very fast. So if they don't do so, then basically it means that they'll actually end up not actually being able to allot the shares. So when you talk about reasonable time, that's within a period under which maybe the investor could actually still be interested in the shares, because interest can actually change very, very, very fast. So the company is quite okay today. The next day you're actually told maybe it is undergoing financial difficulties. It is likely to be liquidated. And yet they had actually allotted the shares. So sorry about that. So I was telling Helen, when you talk about reasonable time, then just within reasonable normal time that you are supposed to make the allotment of the shares, because the interests of basically the investors or shareholders can actually change very fast. So long as you can give evidence that this allotment is not valid, that my interests are no longer with the company because they have delayed to make the allotment, then of course that means basically means that the allotment was not actually made within reasonable time or the required time. But of course, you have said the allotment should actually be done within a period of 60 days after the subscription or closing of the subscription of the shares. Closing of the subscription of the shares, it should actually be within 60 days. But of course, if they make the allotment even maybe within a month or maybe within a period within those particular 60 days, if you as an investor, you can give valid reasons before the court that the allotment is not valid due to maybe delay, then that particular allotment or that particular contract won't actually be binding between you and the company. But the required time for allotment of the shares is actually 60 days. It must be allotted within a period of 60 days. So I hope, Helen, you are okay with that. So there's that question I've actually highlighted there. So I don't know if you have actually gotten the question. Do you have the question? It's November 2017, question 3A. November 2017, question 3A. So I don't know if the others have the question. I can see Brian saying yes. What about Edward? What about Helen? What about Anastasia? Do you guys have the question? Edward has the question. Helen has the question. Anastasia has the question. There's someone else with Infinix. You know, when you enter the meeting with Infinix now, we wonder, how do we call you now? So mostly when you enter the meeting, make sure you indicate your name, because if I start now calling you Infinix Hot 6 Pro, I don't know if Infinix Hot 6 Pro has the question. So get used to entering the meeting with your name. Avoid entering with maybe your phone model. It's not okay. Not okay. So I think we can look at it. It says it is generally unlawful for a company to offer financial assistance to any person for the purpose of purchasing its own shares. So number one, highlight 3 legal consequences of contravening this provision. Then number 2, summarize 2 exceptions to the above statement. So the consequences, number 1, of course, it will be void and illegal. So the contract of the financial assistance will actually be void and illegal. The contract for the financial assistance will actually be void and illegal. So that contract will be void and illegal. It won't be a valid contract of being able to assist another person financially. So the contract will be void and illegal. Then number 2, the company in default shall be liable for a fine. The company in default shall be liable for a fine. The company in default shall be liable for a fine. The company in default shall be liable for a fine, or shall be liable to a fine. Then another one, any officer in the company who was involved in the default shall also be liable for a fine, Any officer in the company who was involved in the default shall also be liable to a fine, Any officer of the company who was involved in the default shall also be liable to a fine. Then the last one, any director involved in the contravention, is guilty. Any director involved in the contravention is guilty and is liable to make good any losses which the company suffers, and is liable to make good any losses which the company suffers, and is liable to make good any losses which the company suffers, Then Roman 2 was asking, provide summarize 2 exceptions to the above statement of providing of financial assistance. So that's why I told you need to be careful. There's that one of aspect of directly purchasing. Then there's the aspect of actually financing. Financing is giving another person money. So in this case, they wanted you to look at those particular exceptions under financing. So don't mention those ones of directly purchasing, like redeeming or preference shares. If you mention those ones, then the examiner will be happy that he has actually tricked you. So in this case, mention those ones about, for example, when we are talking about if the ordinary business of the company is to lend out money. So in such a case, that is actually an exception. To lend out money, then of course they can basically lend out money to be used to purchase the shares of the company. If the company gives out dividends, then of course the shareholders use the dividends to purchase its own shares. If the company has an employee scheme whereby they give money to the employees, or maybe they give loans to the employees, then they use the money to purchase the shares of the company. So that is financing. You are financing another person to purchase the shares of the company. So that is an exception. So there's this one for December 2014. I don't know if you have this one. December 2014, question 6B. December 2014, question 6B. December 2014, question 6B. It says, in Trevor versus Whitworth, rule of 1887, it was held that a company cannot purchase its shares or be a member of itself. However, a company could purchase its shares in certain circumstances. Roman 1, evaluate 3 circumstances in which a company could purchase its own shares. Then Roman 2, identify 3 instances when a company might give financial assistance to facilitate the purchase of its own shares. So that's what we've just covered. So circumstances in which a company could purchase its own shares. We've said, for example, in the case of redemption of redeemable preference shares, a scenario whereby we have a valid surrender of shares by a member, a scenario whereby the company has actually been ordered to purchase shares of an oppressed minority, a scenario whereby we have forfeiture of shares. So in such a case, the company can purchase its own shares. Then they say that's just what you've already looked at. Instances when the company can now give financial assistance or basically finance. So those ones we've just mentioned in our previous answer to that other question, Then maybe you can just look at this one. Maybe this one you can basically tell me the answers. May 2016, question 2A, it says, discuss 5 ways through which a company might raise share capital from the public. So what are the ways through which, it's May 2016, question 2A, discuss 5 ways through which a company might raise share capital from the public. So what do you think are the ways through which a company can raise share capital from the public? Ways through which a company can Yes, discuss 5 ways through which a company might raise share capital from the public. So what do you think are the answers? Those ones you can give me. You can give me. It's May 2016. May 2016, question 2A. Yes, you can try that one. Give me the answer there in the chat. I see if you guys can actually be able to get these things. Redemption of preference shares. Helen, what about Helen? What do you say? Anastasia, what do you say? Valid forfeiture of shares. What about Anastasia and Edward? Edward has given some answers there. It says, discuss 5 ways through which a company might raise share capital from the public. Issue of dividends. Issue of dividends. What of Brian and Helen? What do you think are the ways through which discuss 5 ways through which a company might raise share capital from the public? You can see Helen says offer for sale. Offer for sale, that's correct. Offer for sale is correct. So Helen is saying offer for sale. Which other one? Which other one? Placing is correct. Offer by tender is correct. Offer by tender is correct. Rights issue is correct. So I think you've gotten what the question wanted. So I think you know now the answers. You know, I was wondering why Anastasia and Edward were giving me those other answers. So I don't know why you are giving me the other answers. So they're basically asking methods of actually selling shares. So, you know, when you sell shares, you raise share capital. So means through which you can actually be able to raise share capital is basically through maybe direct offer. You do a direct offer of shares. You do tender of the shares, or offer for sale, or maybe through placing, or maybe through rights issue. So that one was actually a bit maybe tricky. So you need to actually to be very careful when looking at some of these questions. So maybe we can wind up with just 2 things. I think in the next 10 or 15 minutes we'll be through. Then maybe there's something also I want to highlight about this topic. So we can look at reduction or procedure of reducing the share capital of the company. We've seen reduction of share capital as one of the exceptions under the rule in Trevor versus Whitworth, whereby now the company can actually be able to purchase its own shares, shares. But of course, you are saying when you do share capital reduction, it means that you are not maintaining your share capital, because you've said according to the Companies Act or according to the law, the share capital should actually always be maintained. But now you see when you're actually doing share capital reduction, it means that you are not actually basically conforming to that particular requirement. But certain circumstances can actually make the company to reduce its share capital. So basically just reducing it, maybe reducing it from a certain value to maybe downwards. So some of the reasons that could actually make the company decide that we are now going to reduce our share capital, maybe they have unnecessary share capital in the company, which they are not actually maybe going to utilize in the near future. So they have gotten a lot of money from investors, which is just maybe lying idle. So they might not actually utilize it in any time in the near future. So they could decide to do what is known as share capital reduction, reducing the share capital. This basically means that getting the shares back from the investors and giving them their money. We don't want your money in form of share capital in the company because right now it is actually quite excess. We don't actually want it. Then another reason could actually be maybe there are no assets to basically represent this particular share capital. So it means that the assets of the company have actually depleted up to a certain level such that the assets do not actually represent the share capital in the company. Or basically it means that the value of the shares in the company have actually really reduced. So it means that the assets in the company can't represent the share capital. In this particular case, I've told you when the company is raising share capital, it basically uses the money to maybe place in assets. So those assets they actually acquired like maybe 10 years ago are not actually being represented by the share capital currently. So for example, in this case, we talk about non-current assets, then current assets, then capital and liabilities. So then here we talk about capital, which one of it is actually share capital. Share capital. So you add this one to get this particular total. So this side must balance actually with this particular other side. So you have current liabilities. Then we have non-current liabilities. Then we have current liabilities. Basically, it means that what is actually in this side is represented by what is actually this other side. So when you talk about share capital being represented by assets, when you contribute your money in terms of share capital by giving money to the company, they put the money in assets. For example, they acquire machinery, they acquire land, they acquire maybe go downs to maybe store goods. So your share capital is being represented by assets. So they acquire machinery, like for example, you invested in the company 5 years ago, they acquired machinery, but now the machinery have actually depreciated. Do you think this particular value here is being represented by the depreciated asset after 5 years? No, this particular value has actually really reduced. So for example, if there are no assets to represent the share capital, the company can decide to do what is known as share capital reduction. And even it means that, for example, if the value of the shares 5 years ago were actually maybe at a higher value, they have actually really now reduced. So it means that the assets, there are no assets to represent this particular share capital. So the company can decide to do what is known as share capital reduction. So those could be some of the reasons as to why the company wants to do what is known as share capital reduction. Just from the word share capital reduction, reducing the share capital. The reason there are no assets to represent the share capital, or maybe it could be the company has excess capital, or there's excess capital that it doesn't actually maybe need maybe in the near future. So they can reduce the share capital by basically buying back the shares of the company. That's why we've said under some of the reasons that could actually, or reasons conduct, some of the exceptions, we've said that one of them is actually a valid reduction of share capital. So that's how the company will likely be able to reduce its share capital. So there is a procedure that has to be followed, because you've said this particular reduction of share capital will likely be going against the requirement of maintaining share capital. Because if you reduce your share capital, it means that you are not maintaining the share capital for the benefit of the creditors if the company is liquidated. So it has to be a valid way through which the company, there has to be a valid way through which the company is reducing its share capital. So the procedure of actually being able to reduce the share capital, so there is a procedure for share capital reduction. for share capital reduction. Share capital procedure for share capital reduction. Procedure for share capital reduction. So one of the key things that will likely happen if the company intends to reduce its share capital, it basically means that the first thing that will likely happen, the company will convene a general meeting in the company. So number one is convening of a general meeting in a company. Then at this particular meeting, they'll pass what is known as a special resolution. A special resolution that is supposed to be approved by, special is the one that we said is supposed to be approved by at least 75% of members allowed to attend and vote at such kind of a meeting. So it must be approved by at least 75% of the voting rights of the members of the company. So the first thing is to convene a general meeting. In that particular general meeting, they pass a special resolution that they want the company to reduce its share capital. Then what will likely happen after passing of the special resolution, that particular special resolution will likely be used to seek for a petition from the courts. So now they have met, they have passed a resolution, they prepare the resolution, they go to the court, petition the court, ask for permission of reduction of share capital. So once the court receives that particular petition, what will likely happen? The court will likely seek for a list of all the creditors of the company. So this is now where you actually realize now the creditors are actually very protected with regard to the share capital. All the creditors of the company will be listed. So once they have actually been listed, they'll basically inform them of the intention of the company to be able to do what is known as share capital reduction. If there is any creditor who is objecting to the share capital reduction, and of course you already know the reason a creditor could actually object, because you are saying share capital is the fund of last resort to the creditors in case the company is liquidated. It means that if the company is reducing the share capital, then at the end of the day, if the company is liquidated, the creditors are likely not to get anything from the company because maybe there are no assets that have been sold, reducing the share capital, because this share capital is being represented by assets. So if the company has maybe sold off the assets, or maybe they are deciding to do a share capital reduction, it means that the creditors won't actually have a fund of last resort in case the company is liquidated. That's why it is important for the court to be able to enlist all the creditors and actually inform them of the intention of the company to be able to do what is known as share capital reduction. If there's any creditor who is actually objecting, of course, what the court will likely do, they'll basically ask the company to dispense off with the creditor. By dispensing off, it means they decide they're going to pay him all the due amounts for the creditor. For example, if the company is owing the creditor, for example, 10 million, they ask the company, pay off this particular creditor because he's actually objecting to your permission to be able to do what is known as share capital reduction. So the company, if the company goes and actually dispenses off with that particular creditor, then of course the courts will basically now issue the permission or give the order for the company to be able to do what is known as share capital reduction. So in such a case, it will be seen that the company has actually been able to follow the correct procedure of doing share capital reduction. So if there is no any other creditor who is actually objecting, they have already dispensed off with the creditor who is actually objecting, the company or the court will basically give the permission or give the order for the company to be able to do what is known as share capital reduction. So once they have done so, the company is actually at liberty to choose any method or any means through which they likely be able to do the share capital reduction. Maybe they could decide they are going to do shares buyback, or maybe reduce the value of the shares in the company, or maybe they could decide they are going to merge the shares and reduce the value. So it depends with how the company decides they are going to do the share capital reduction. So that is at the liberty of the company. But of course, you are saying the court must actually give the go-ahead for the company to be able to do the share capital reduction. So that is basically the procedure of how the company can actually be able to do what is known as a share capital reduction. Share capital reduction. So we are saying, number one, the company convenes a general meeting. Number two, a special resolution is actually passed at the meeting. Then that particular special resolution will likely be used to seek for a petition from the court, or the company will use that one to petition the court to basically seek for an order for share capital reduction. Once the court receives that particular petition, they enlist all the creditors of the company. Then, of course, if there's any creditor who is actually objecting, and I've told you the reason as to why a creditor can actually object, then, of course, they'll ask the company to dispense off with the creditor, pay the creditor so that there's no one who is actually objecting to the reduction of the share capital. If they have already dispensed off with the creditor, and the others are actually okay, then of course the court will give a go ahead for the company to be able to do what is known as share capital reduction. So that's why we are saying basically this particular share capital should actually be always be maintained, because those ones or the key stakeholders in the company are actually being protected under the law are actually the creditors of the company. Because if they are not actually protected, it means that maybe even the directors can actually misappropriate the share capital of the company by maybe selling off some of the assets and not maintaining the share capital. Therefore, they won't have the fund of last resort in case the company is actually liquidated. So that is basically the procedure that must actually be followed when the company is actually going to do what is known as share capital reduction, share capital reduction. So the last thing we are supposed to look at under this particular topic is basically just dividends. So what is dividends? Dividends, and how the dividends can actually be paid. Dividends can actually be paid. So basically, when you talk about dividends, these are basically the profits of the company that are usually distributed to the shareholders. So if you have shares in a company, you become a shareholder. Then once the company makes profits, they basically distribute the profits. So those profits distributed to the members, then of course they are termed as being dividends. So they'll be termed as being dividends of the company. So what will actually happen in a company, the dividends will likely be proposed by the directors of the company. So they just propose, we are going to pay this year maybe 2 shillings per share as dividends. Then it will likely be approved at the AGM. So at the AGM or the annual general meeting, that's where now the members of the company basically approve that particular proposed dividends by the directors of the company. So the dividends will be paid to the registered members of the company. It could be through any means, the way you actually want. Maybe you want via check. So they'll ask you, do you want the dividends via check? Do you want the dividends to be paid via M-Pesa? Do you want the dividends to be maybe directly credited on your bank account through EFT, electronic funds transfer? So you'll basically be able to explain to the company how you want the dividends to be paid by being able to fill out what is known as a dividends mandate. So a dividends mandate is a request form of any shareholder having a bank account to basically detail how he wants the dividends to be paid. So there'll be, of course, be a dividend voucher that will be given, or a dividend warrant. So payments of dividends are normally done by the company sending the registered members dividend warrants, which contains 2 parts. So an advice informing the members of the particulars of the payment, and a warrant proper, which is the form of a check and directs the company's bank to pay the sum due to the members. So the dividend warrant will basically contain the full registered name of the company, the address of the company, and the company paying the dividends, the full name of the security which is the dividends is being paid for. Are they preference shares? Are they ordinary shares? Then the date of the payment of the dividends, then the period to which the dividends relates, the amount of dividends, and of course there's a tax that is usually paid on dividends known as withholding tax. So they'll indicate the withholding tax that is going to be deducted from your dividends. Then it will likely be signed by an officer of the company. Mostly it is usually the company secretary, because under company secretary, the duties of the company secretary, some of them include basically to send out the dividend warrants or maybe the dividend vouchers. Then of course there's a dividend mandate that will basically ask the shareholder to give directions on how he wants the dividends to be paid. Do you want the dividends to be paid by your bank, or maybe through which means? So that's when you can actually clearly indicate it in the dividends mandate. So you have a dividend voucher or a dividend warrant. Basically, this one you are saying it details the amount of dividends, how is it actually going to, or on which securities are they actually going to pay the dividends, the date of payment, basically the name of the company paying the dividends, its address, then maybe it will be signed by the secretary of the company, of the company. Then sometimes the company could decide it is not actually going to pay all its profits as dividends. So they could actually put aside some of the profits This is what we actually term as capitalization of the profits, or basically profits that are usually put aside. So they are not actually fully paid to the shareholders. So they put aside, for example, if the company makes maybe, let's say, for example, 30 billion as a profit. So they could decide that they are not actually going to basically pay all the amounts as actually a dividend. So they could put aside some part of the profits as reserve funds, So this one will actually go to the reserve and pay the remaining 15 billion as dividends. Or maybe they could decide this year they are not going to pay the dividends, and basically they are going to capitalize all the profits. So it means that they ask you as a shareholder, instead of actually you basically getting the dividends, maybe you could actually get extra shares in the company. So in such a case, they basically capitalize the profits and not actually distribute them as dividends. So instead of paying dividends, they convince shareholders, instead of us giving you dividends, we can use this part of your amount of, in terms of distributable profits, to convert it into becoming share capital by giving you extra shares in the company. So they capitalize the profits, or maybe they could put aside some of the profits as reserve funds. So the company has an option of actually capitalizing the profits, or maybe putting aside some of the profits as reserve funds, So I think that's all you need to know about share capital. So the secret of actually being able to understand this particular topic very properly, you read it repetitively. So that you don't forget most of these things. So I want us to look at a question. It is May 2019, question 1B. It is May 2019, question 1B. It is May 2019, question 1B. I don't know if you have it. May 2019, question 1B. I don't know if you have this past paper. May 2019, question 1B. Could you be having it, or you don't have it? We write the question. May 2019, question 1B. Yes, Helen has it, and then Brian actually also has it. I don't know if Anastasia has it. Yes, we have it. So it says, state 4 exceptions to the rule that a company should not issue shares at a discount. So you've seen that I've clearly stated that shares shouldn't, it is prohibited for a company to issue shares at a discount. But of course, there are a few exceptions whereby it can actually be able to issue shares at a discount. Then number 2, explain 3 roles of the court in reduction of the company's capital. So that was a question from share capital reduction. So exceptions, you can capture these ones. Exceptions to the rule that a company should not issue shares at a discount. So if such an issue, if the issue is authorized by a resolution, if the issue of the shares at a discount is authorized by a resolution in a general meeting. If the issue is authorized by a resolution passed in a general meeting of the company. If the issue is authorized by a resolution passed in a general meeting of the company. If the issue is authorized by a resolution passed in a general meeting of the company. Then number 2, if not less than a year has passed or elapsed since the company was allowed to commence business. If not less than a year has elapsed since the company was entitled to commence business. Since not less than a year has elapsed since, if not less than a year has elapsed since the company was entitled to commence business. So this means that the company is actually a bit stable. It can actually now take the risk of issuing shares even at a discount, because it can get other sources of funds to be able to cover for the discount. So if not less than a year has elapsed since the company was entitled to commence business. Then number 3, the shares to be issued must be of a class already issued. The shares to be issued must be of a class already issued. The shares to be issued must be of a class already issued. The shares to be issued must be of a class already issued. The shares to be issued must be of a class already issued. The shares issued must be of a class already issued. Then the next one you can talk about, the issue is sanctioned by the court, or basically the issue is actually approved by the court. The issue is sanctioned by the court. The issue is sanctioned or approved by the court. The issue is sanctioned or approved by the court. The issue is sanctioned or approved by the court. Then the last question we can actually look at today. Explain 3 roles of the court in reduction of the company's capital. So the first one, this one is actually also captured in the notes I actually shared with you guys. So the court shall make a list of all the creditors entitled to object to such a reduction. So that is the first role. The court will make a list of all the creditors entitled to object to such a reduction and the amounts respectively owed to them. The number 2, the court will also fix a debt of a creditor who had been excluded from the list to be included, or to demand to be included. The court will fix a debt for a creditor excluded from the list. Will set a debt for a creditor who had been excluded from the list to demand to be included. Then number 3, the court will order the company to dispense off with creditors. The court will order the company to dispense off with creditors objecting to the reduction of the share capital, or order the company to dispense off. The court will order the company to dispense off the creditors objecting to the reduction of the share capital before it can issue a consent for the reduction. Then the last thing that it likely do, for example, if the company has conformed, the court will issue an order for reduction of share capital, or basically approve the petition for share capital reduction. So it will have a bigger say in terms of now giving an order that the company is now okay. It has conformed with all the requirements of doing a share capital reduction. Share capital reduction. Share capital reduction. So I think we can call it a day for today. With that, we can actually call it a day with that. So I think we've ended. We come to the end of this particular topic of share capital. So I think maybe there was an assignment I gave, but I don't know if you guys are tempted. So maybe what you do, you can, I think you are like, just like those ones who are here today. You are like 4 or 5 last time. So maybe you can just do a photo and maybe send it. I have a look at it. But there's one I want to leave today, so that there's an aspect I haven't taught, but it's actually in your notes. It is touching on the issue of paying dividends out of capital. But maybe you can just do your research. It is actually in the notes I shared. It's the only thing I haven't touched on, but I'm just thinking that instead of me touching on it, I've given you a clue or evidence. Maybe I've given you a way on how you can actually be able to explain some of these things. I can give you an assignment. So maybe just write it somewhere. And it was actually tested in November 2018, but it says, summarize 6 circumstances under which a company, you can write it down, summarize 6 circumstances under which a company might pay interest out of capital. Summarize 6 circumstances under which a company might pay interest out of capital. Might pay interest out of capital. So summarize 6 circumstances under which a company might pay interest out of capital. So you can just do your own research. You know, with you doing research, you'll actually be able also to revise a bit instead of just having to forget about these things very quickly. And we know there'll be a question from this particular topic in the exam. So there's just one key topic I have concern with is debt capital. Then I think those guys, I started with online classes, then you guys should actually now be good to go. The only thing that will be remaining with you guys is just to see what CASNEP decides, then we do revision or block revision. Then with that, I think your confidence level to face the exam will be, you'll be quite okay now. You'll be quite okay. You'll be quite okay now to face the exam. So once we just know the date, then we do block revision. We touch on what is likely to come in the exam, then we'll be good to go. So I still intend to touch on debt capital. So there are usually 4 key topics for my concern, which students actually like forgetting about. But I normally tell my students, if you understand these particular topics, then don't expect the exam to give you a lot of problems. So you can know shares well, know share capital well. Then understand debt capital well. Then of course, know formation. So if you understand these particular topics quite well at your fingertips, then you'll get an easy time in the exam room. So all those other ones are usually very small topics. You can just even think and give the answers. So they are not really tough as compared to these particular topics. These ones are actually very key. So they are of very key concern. You need to understand them very properly. So if you understand them, then company law, you'll actually pass very easily. I think we can end there today. So you guys can have a good evening. Enjoy your evening. We'll meet next time. So of course, the next session for this class is next Saturday. So we'll see what will actually happen, maybe next Saturday. But you can just attempt the assignment and do a photo and just send me so that I see if you guys are actually comprehending some of these things. Otherwise, you can have a good evening. We'll meet in the next class. Bye-bye.